Privacy of Communication and Correspondence, Section 3, Article 3. The privacy of communication and correspondence shall be inviolable except upon lawful order of the court, or when public safety or order requires otherwise as prescribed by law. Number 2. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. Inviolability exceptions. Lawful order of the court, or by when public safety or order requires otherwise as may be provided by law. The guarantee includes, without the mantle of its protection, tangible as well as intangible objects. Read in connection with RA 4200 Anti-Wiretapping Act. In Ramirez versus Court of Appeals, GR 93833, September 28, 1995, it was held that RA 4200 clearly and unequivocally makes it illegal for any person not authorized by all the parties to any private communication to secretly record such communications by means of a tape recorder. The law does not make any distinction. In Gaanan versus Intermediate Appellate Court, GRL 69809, it was held that a telephone extension was not among the devices covered by this law. Number 3, the right may be invoked against the wife who went to the clinic of her husband and there took documents consisting of private communications between her husband and his alleged paramour. Solieta versus Court of Appeals. However, in Waterous Drug Corporation versus NLRC, GR 113271, the Supreme Court said that a Bill of Rights does not protect citizens from unreasonable searches and seizures made by private individuals. In this case, an officer of the petitioner corporation opened an envelope addressed to the private respondent and found therein a check evidencing an overprice in the purchase of medicine. Despite the lack of consent on the part of the private respondent, the check was deemed admissible in evidence. Exclusionary rule. In Wenceslao Loretta, 140 Scra 382, letters addressed by a lawyer of one of the parties to a case, addressed to individual justices of the Supreme Court in connection with the performance of their judicial functions, become part of the judicial record and are a matter of concern for the entire court, and thus are not covered by the constitutional guarantee. In People versus Albufera, L69377, a letter written by the accused to a witness which was produced by the witness during the trial is admissible in evidence. It was not the result of an unlawful search, nor through an unwarranted intrusion or invasion into the privacy of the accused. It was produced by the recipient of the letter who identified the same. Besides, there is nothing self-incriminatory in the letter. The right to privacy is the right to be free from unwarranted exploitation of one's person or from intrusion into one's private activities in such a way as to cause humiliation to a person's ordinary sensibilities. It is the right of an individual to be free from unwarranted publicity or to live without unwarranted interference by the public in matters in which the public is not necessarily concerned. Simply put, the right to privacy is the right to be let alone. The Bill of Rights guarantees the people's right to privacy and protects them against the state's abuse of power. In this regard, the state recognizes the right of the people to be secure in their houses. No one, not even the state, except in case of overriding social need and then only under the stringent procedural safeguards, can disturb them in the privacy of their homes. Espouses Hing versus Chui. That's GR 1797-36. 3 strands of the right to privacy. 1. Locational or situational privacy, the privacy that is felt in physical space, such as that which may be violated by trespass and unwarranted search and seizure. Informational privacy, that's number 2, the right of individuals to control information about themselves. And number three, decisional privacy, the right of individuals to make certain kinds of fundamental choices with respect to their personal and reproductive autonomy. Vivares versus St. Teresa's College. GR 202666. Zones of privacy. Relevant to any discussion of the right to privacy is the concept known as the zones of privacy. Zones of privacy are recognized and protected in our laws. Within these zones, any form of intrusion is impermissible unless excused by law and in accordance with customary legal process. The meticulous regard we accord to these zones arises not only from our conviction that the right to privacy is a constitutional right and the right most valued by civilized men, but also from our adherence to the Universal Declaration of Human Rights, which mandate that no one shall be subjected to arbitrary interference with his privacy, and everyone has the right to the protection of law against such interference or attacks. Disney versus Secretary of Justice. The right of privacy is recognized and enshrined in several provisions of the Bill of Rights. Section 3, Privacy of Communication and Correspondence. Section 1, Due Process of and Equal Protection, Right to Life, Liberty, and Property. Section 2, Right against Unreasonable Searches and Seizures. Section 6, Liberty of Abode and Right to Travel. Section 8, Right to Form Associations. Section 17, Right against Self-Incrimination. Ople versus Torres. 127685. Zones of privacy are likewise recognized and protected in our laws and rules. Civil Code, RPC, Anti-Wiretapping Law, Secrecy of Bank Deposits Act, Intellectual Property Code, Rules of Court. It's the same case, Ople versus Torres. Concept of communication and correspondence. Forms of communication and correspondence considered private and protected by this provision include letters, messages, telephone calls, telegrams, and the like. This is from Bernas, the 1987 Constitution of the Republic of the Philippines, 2009. Reasonable expectation of privacy test. In ascertaining whether there is a violation of the right to privacy, courts use the reasonable expectation of privacy test. This test determines whether a person has a reasonable expectation of privacy and whether the expectation has been violated. The reasonableness of a person's expectation of privacy depends on a two-part test. Subjective, whether by his conduct the individual has exhibited an expectation of privacy, and objective. This expectation is one that society recognizes as reasonable. Paula versus Constantino David, 1881. Customs, community norms, and practices may, therefore, limit or extend an individual's reasonable expectation of privacy. Hence, the reasonableness of a person's expectation of privacy must be determined on a case-to-case basis, since it depends on the factual circumstances surrounding the case. Spouses Hing versus Chui. In assessing the challenge that the state has impermissible or impermissibly intruded into these zones of privacy, a court must determine whether a person has exhibited a reasonable expectation of privacy, and if so, whether that expectation has been violated by unreasonable government intrusion. That's the Disney case. A government employee has a burden of proving that he has legitimate expectation of privacy either in his office or computer files. He can prove this by alleging and demonstrating the following. He used a password on his computer, did not share his office with a coworker, and kept the same locked. However, the existence of a workplace privacy policy may limit or erode the reasonable expectation of privacy. This is the case of Paulo versus Constantino David. Private communication can be made public. Private communications can be made public, whereas secret involves public questions which the state should and ought to know. The state may infringe the privacy of communication by some process or by appealing to the court for the purpose of determining whether or not the privacy should be maintained. The court may allow intrusions on privacy of communication and correspondence only on the ground of probable cause. That is from the Book of Bernas. Public figure. The right of privacy of a public figure is necessarily narrower than that of an ordinary citizen. Ayer versus Capullo. Personal matters. Section 7, Article 3 of the 1987 Constitution grants the right of the people to information on matters of public concern. Personal matters are exempt or outside the coverage of the people's right to information on matters of public concern. The data treated as strictly confidential under EO 420 being private matters and not matters of public concern, this data cannot be released to the public or the press. KMU versus Director General of NEDA, the GR 167798. Intrusion when and how allowed. The privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. Probable cause required. The constitutional text does not give any ground. It is submitted that the requirements of probable cause in the preceding section, Article 3, Section 2, should be followed. After all, the privacy right is but an aspect of the right to be secure in one's person. Prescribed by law. It should be based upon a government official's assessment that public safety and order demands such intrusion as provided by law. It is not only that the discretion of the executive officer is limitable by law, but also that a public officer who exercises this power must be able to point to a law under which he acts. Public order and safety, the security of human lives, liberty, and property against the activities of invaders, insurrectionists, and rebels. So, the exclusionary rule, any evidence obtained in violation of the right to privacy of communication and correspondence shall be inadmissible for any purpose in any proceeding. To come under the exclusionary rule, however, the evidence must be obtained by government agents and not by private individuals acting on their own. This does not mean, however, that private individuals cannot be held liable. Almost all these liberties are also guaranteed by Article 32 of the Civil Code, making private violations actionable even if the violation does not have a constitutional consequence, such as the applicability of the exclusionary rule. Same book, Bernas. Exclusionary rule will not apply if the recipient of the message granted access to the messages sent. This is the case as Office of the Court Administrator versus Judge Elisa. U. Applied to wife who took documents and papers from husband's clinic without the latter's knowledge and consent. The constitutional injunction declaring the privacy of communication and correspondence to be inviolable is no less applicable simply because it is the wife who thinks herself aggrieved by her husband's infidelity, who is the party against whom the constitutional provision is to be enforced. The only exception to the prohibition in the Constitution is if there is a lawful order from a court or when public safety or order requires otherwise, as prescribed by law. And a violation of this provision renders the evidence obtained inadmissible for any purpose in any proceeding. The intimacies between husband and wife do not justify any one of them in breaking the doors and cabinets of the other and in ransacking them for any telltale evidence of marital infidelity. A person by contracting marriage does not shed his or her integrity or its right to privacy as an individual, and the constitutional protection is ever available to him or to her. The law ensures absolute freedom of communication between the spouses by making it privileged. Neither husband nor wife may testify for or against the other without the consent of the affected spouse while the marriage subsists. Neither may be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage, save for specified exceptions. But one thing is freedom of communication. Quite another is a compulsion for each one to share what one knows with the other. And this has nothing to do with the duty of fidelity that each owes to the other. Sulieta versus CA. RA 10175 Cybercrime Prevention Act. We're going to include this because I can't find this in the book of Nachura. Certain cybercrime offenses under RA 10175 were assailed for violating both the right against unreasonable searches and seizures and the right to privacy. The court held that relevant to any discussion of the right to privacy is the concept known as the zones of privacy as discussed earlier. In assessing the challenge that the state has impermissibly intruded into these zones of privacy, a court must determine whether a person has exhibited a reasonable expectation of privacy, and if so, whether that expectation has been violated by unreasonable government intrusion. The usual identifying information regarding a person includes his name, his citizenship, his residence address, his contact number, his place and date of birth, the name of his spouse, if any, his occupation, and similar data. The law punishes those who acquire or use such identifying information without right implicitly to cause damage. Petitioners failed to show how government effort to curb computer related identity theft violates the right to privacy and correspondence as well as the right to due process of law. However, Section 12 on real time collection of traffic data was declared unconstitutional for the authority that Section 12 gives law enforcement agencies is too sweeping and lacks restraint. While it says that traffic data collection should not disclose identities or content data, such restraint is but an illusion. Admittedly, nothing can prevent law enforcement agencies holding these data in their hands from looking into the identity of their sender or receiver and what the data contains. This will unnecessarily expose the citizenry to leaked information or worse, to extortion from certain bad elements in these agencies. Section 12, of course, limits the collection of traffic data to those associated with specified communications. But this supposed limitation is no limitation at all, since evidently it is the law enforcement agencies that would specify the target communications. The power is virtually limitless, enabling law enforcement authorities to engage in fishing expedition, choosing whatever specified communication they want. This evidently threatens the right of individual to privacy. Same case, Disney versus Secretary of Justice. How about RA 4200, Anti-Wiretapping Act? Only protects letters, messages, telephone calls, telegrams, and the like. Letter B, the substance of the conversation need not be specifically alleged in the information. Letter C, under Section 3 of RA 4200, a peace officer who is authorized by a written order of the court may execute any of the acts declared to be unlawful in the said law in cases involving the crime of 1. Treason, espionage, provoking war and disloyalty in case of war, privacy and mutiny and the high seas, rebellion, conspiracy and proposal to commit, inciting to commit. Number 6, sedition, conspiracy to commit and inciting to commit. Number 7, kidnapping. 8, violations of CA number 616 or punishing, espionage, and other offenses against national security. Letter D, RA 4200 does not distinguish between a party to the private communication or a third person. Hence, both could be held liable under RA 4200 if they commit any of the prohibited acts under the Act, Ramirez versus CA. The use of a telephone extension to overhear a private conversation is not a violation of RA 4200 because it is not similar to any of the prohibited devices under the law. Also, a telephone extension is not purposely installed for the purpose of secretly intercepting or recording private communication. Gaanan versus IAC. How about online social network privacy? Before one can have expectation of privacy in his or her online social network activity, it is first necessary that said user manifest the intention to keep certain posts private. In the cyber world, utilization of privacy tools in the manifestation of the user's invocation of his or her right to informational privacy. That the photos are viewable by friends only does not necessarily bolster the contention to the right to privacy. In this regard, the cyber community is agreed that the digital images under the settings still remain to be outside the confines of the zones of privacy in view of the following. Number one, Facebook allows the world to be more open and connected by giving its users the tools to interact and share in any conceivable way. Number two, a good number of Facebook users befriend other users who are total strangers. Number three, the sheer number of friends one user has, usually by the hundreds. And four, a user's Facebook friend can share the former's post or tag others who are not Facebook friends with the former, despite its being visible only to his or her own Facebook friends. Setting up posts or profile details privacy to friends is no assurance that it can no longer be viewed by another user who is not Facebook friends with the source of the content. Therefore, a Facebook user who opts to make use of a privacy tool to grant or deny access to his or her posts or profile detail should not be denied the informational privacy right which necessarily accompanies said choice. Otherwise, using these privacy tools would be a feckless exercise, such that if, for instance, a user uploads a photo or any personal information of his or her Facebook page and sets it to privacy level at only me or a custom list so that only the user or a chosen few can view it, said photo would still be deemed public by the courts as if the user never chose to limit the photo's visibility and accessibility. Such position, if adopted, will not only strip these privacy tools of their function, but it would also disregard the very intention of the user to keep said photo or information within the confines of his or her private space. Vivares versus St. Teresa's College. GR 202666, if you want to read it. How about the writ of habeas data? The writ of habeas data is a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened by an unlawful act or omission of a public official or employee or of a private individual or entity engaged in the gathering, collecting, or storing of data or information regarding a person, family, home, and correspondence of the aggrieved party. The purpose, it bears reiteration that, like the writ of amparo, habeas data was conceived as a response, given the lack of effective and available remedies to address the extraordinary rise in the number of killings and enforced disappearances. Its intent is to address violation of or threats to the right to life, liberty, or security as a remedy independently from those provided under prevailing rules. Writs of amparo and habeas data will not issue to protect purely property or commercial concerns, nor when the grounds invoked in support of the petition, therefore, are vague or doubtful. Employment constitutes a property right under the context of the Due Process Clause of the Constitution. It is evident that respondents' reservations on the real reasons for her transfer, a legitimate concern respecting the terms and conditions of one employment, are what prompted her to adopt the extraordinary remedy of habeas data. Manila Electric Company versus Lim 184679. Who may file this? In a person whose right to privacy is threatened. Number two, in case of extrajudicial disappearances or killings, the spouse, children, and parents. Letter B, any ascendant, descendant, or collateral relative of the aggrieved party within the fourth civil degree of consanguinity or affinity in default of those mentioned in the preceding paragraph. National believed inmates. The right of a convicted national inmate to his or her privacy runs counter to the state interest of preserving order and security inside our prison system. There is no longer any reasonable expectation of privacy when one is being monitored and guarded at all hours of the day. unless there is compelling evidence that a public employee engaged in the gathering, collecting, or storing of data or information on the convicted national inmate has committed an unlawful act which threatens the life of the inmate. A petition for the writ of habeas data cannot prosper. This is in the matter of the petition for writ of habeas data corpus versus De Lima. Freedom of speech and expression. This is Section 4, Article 3. No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. The concept is freedom of expression has gained recognition as a fundamental principle of every democratic government and given a preferred right that it stands on a higher level than substantive economic freedom or other liberties. In the Philippines, the primacy and high esteem accorded freedom of expression is the fundamental postulate of our constitutional system. This right was elevated to the constitutional status in the 1935 and 1973 and the 1987 Constitution, reflecting our lesson or our own lesson of history, both political and legal, that freedom of speech is an indispensable condition for nearly every other form of freedom. Chavez versus Gonzalez, GR 168338. Continuum of thought, speech. Speech may be said to be inextricably linked to freedom itself, as the right to think is the beginning of freedom, and speech must be protected from the government because speech is the beginning of thought. Diocese of Bacolod versus Comelec, citing Bernas from the records of 1987 Constitution. Communication is an essential outcome of protected speech. Communication exists when one speaker, seeking to signal others, uses conventional actions because he or she reasonably believes that such action or actions will be taken by the audience in the manner intended, and two, the audience so takes the actions. In communicative action, the hearer may respond to the claims by either accepting the speech acts, claims, or opposing them with criticism or requests for justification. Speech is not limited to vocal communication. Conduct is treated as a form of speech, sometimes referred to as a symbolic speech, such that when speech and non-speech elements are combined in the same course of conduct, the communicative element of the conduct may be sufficient to bring into play the right to freedom of expression. The right to freedom of expression thus applies to the entire continuum in speech, from utterances made to conduct enacted, and even to inaction itself as a symbolic manner of communication. Same case, Diocese of Bacolod versus Comelec, 205728. The scope of freedom of extends protection to freedom of speech. Written or spoken words, symbolic speech, motion pictures. Includes the right to be silent. Freedom of speech includes the right to be silent. Aptly has it been said that the Bill of Rights that guarantees to the individual the liberty to utter what it is in his mind also guarantees to him the liberty not to utter what is not in his mind. Protects speech. The scope of freedom of expression is so broad that it extends protection to nearly all forms of communication. It protects 1. Speech, 2. Printing, 3. Assembly regarding secular as well as political causes, and is not confined to any particular field of human interest. The protection covers my right matters of public interest or concern, embracing all issues about which information is needed or appropriate, so as to enable members of society to cope with the exigencies of their period. The constitutional protection is not limited to the exposition of ideas. The protection afforded free speech extends to speech or publications that are entertaining as well as instructive or informative, All forms of media, whether print or broadcast, are entitled to the broad protection of the clause on freedom of speech and oral expression. The constitutional protection assures the broadest possible exercise of free speech and free press for religious, political, economic, scientific, news, or informational ends, inasmuch as the Constitution's basic guarantee of freedom to advocate ideas is not confined to the expression of ideas that are conventional or shared by a majority. Same case. There are several theories and schools of thought that strengthen the need to protect the basic right to freedom of expression. One, the right of the people to participate in public affairs, including the right to criticize government actions, speech that promotes dialogue in public affairs, or airs out grievances and political discontent should thus be protected and encouraged. Letter B, free speech should be encouraged under the concept of a marketplace of ideas based on the theory that the ultimate good desired is better reached by the free trade in ideas. Letter C, free speech involves self expression that enhances human dignity. This right is a means of assuring individual self fulfillment, among others. Letter D, expression is a marker for group identity. Free speech must be protected as the vehicle to find those who have similar and shared values and ideals, to join together and forward common goals. Letter E, the Bill of Rights, free speech included, is supposed to protect individuals and minorities against majoritarian abuses perpetrated through the framework of democratic governance. Majoritarianism is a political philosophy or ideology with the agenda asserting that a majority based on a religion, language, social class, or other category of the population is entitled to a certain degree of primacy in society and has the right to make decisions that affect the society. That's from Wikipedia. Letter F, free speech must be protected under the safety valve theory. This provides that nonviolent manifestations of dissent reduce the likelihood of violence. Free speech must thus be protected as a peaceful means of achieving one's goal, considering the possibility that repression of nonviolent dissent may spill over the violent means a point just to drive a point. Diocese versus McCullough. Balance between unbridled expression and liberty. From the language of Section 4, the right to free speech and a free press is not susceptible of any limitation. But the realities of life in a complex society preclude a literal interpretation of the provision prohibiting the passage of a law that would abridge such freedom. For freedom of expression is not an absolute, nor it is an unbridled license that gives immunity for every possible use of language and prevents the punishment of those who abuse this freedom. Thus, all speech are not treated the same. Some types of speech may be subjected to some regulation by the state under its pervasive police power, in order that it may not be injurious to the equal right of others or those of the community or society. Chavez versus Gonzalez. The freedom of expression, as with the other freedoms encast in the Bill of Rights, is however not absolute. It may be regulated to some extent to serve important public interests, some forms of speech not being protected. The limits of the freedom of expression are reached when the expression touches upon matters of essentially private concern. The constitutional guarantee obviously was not intended to give immunity for all every possible use of language. The freedom to express one's sentiments and belief does not grant one the license to vilify in public the honor and integrity of another. Any sentiments must be expressed within the proper form and with proper regard for the right of others. Soriano versus LaGuardia, GR 164785. Two types of regulation: prior restraint and subsequent punishment. Prior restraint or censorship. Concept: Prior restraint refers to official governmental restriction on the press or other forms of expression in advance of actual publication or dissemination. Freedom from prior restraint is largely freedom from government censorship of publications, whatever the form of censorship, and regardless of whatever it is wielded by the executive, legislative, or judicial branch of the government. This is from Chavez versus Gonzalez, GR 168338, where Justice Nachura has a dissenting opinion saying that the assailed press release and statements do not constitute a prior restraint on free speech. It was not improper for the NTC to warn the broad media that the airing of taped materials, if subsequently shown to be false, would be a violation of law and of the terms of their certificate of authority and could lead, after appropriate investigation, to the cancellation or revocation of their license. Let's see what the Supreme Court said about this. In Federal Commission FCC versus League of Women Voters in America, it was held that we have long recognized that Congress, acting pursuant to the Commerce Clause, has power to regulate the use of this scarce and valuable national resource. The distinctive feature of Congress' efforts in this area has been to ensure through the regulatory oversight of the FCC that only those who satisfy the public interest, convenience, and necessity are granted a license to use radio and television broadcast frequencies. In the Philippines, it is the respondent NTC that has regulatory powers over the telecommunications networks. In Republic Act number 7925, the NTC is denominated as its principal administrator and as such shall take the necessary measure to implement the policies and objectives set forth in the Act. Under Executive Order 546, the NTC is mandated, among others, to establish and prescribe rules, regulations, standards, and specifications in all cases related to the issued certificate of public convenience, promulgate rules and regulations of public safety and interest may require, and supervise and inspect the operation of radio stations and telecommunications facilities. The NTC exercises quasi-judicial powers. The issuance of the press release by NTC was well within the scope of its regulatory and supervision function, part of which is to ensure that the radio and television stations comply with the law and the terms of their respective authority. Thus, it was not improper for the NTC to warn and the broadcast media that the airing of tape materials, if subsequently shown to be false, would be a violation of law of the terms of their certificate of authority and could lead, after appropriate investigation, to the cancellation or revocation of their license. The same case. Courts have traditionally recognized two cognate and complementary facets of freedom of expression, namely freedom from censorship or prior restraint and freedom from subsequent punishment. The first guarantees untrammeled right to expression, free from legislative, administrative, or judicial orders, which would effectively bar speech or publication even before it is made. The second prohibits the imposition of any sanction or penalty for the speech or publication after its occurrence. Freedom from prior restraint has enjoyed the widest spectrum of protection, but no real constitutional challenge has been raised against the validity of laws that punish abuse of the freedom, such as the laws on libel, sedition, or obscenity. Prior restraint is generally understood as an imposition in advance of a limit upon speech or other forms of expression. In determining whether a restriction is a prior restraint, one of the key factors considered is whether the restraint prevents the expression of a message. In Nebraska Press Association versus Stewart, U.S. Supreme Court declared that a prior restraint, by definition, has an immediate and irreversible sanction. If it can be said that a threat of criminal or civil sanctions after publication chills speech, prior restraint freezes it, at least for the time. As an aspect of freedom of expression, prior restraint should not be confused with subsequent punishment. In Alexander versus U.S., petitioner complaint was that The RICO for feature provisions on businesses dealing in expressive materials constituted prior restraint because they may have an improper chilling effect on free expressions by deterring others from engaging in protected speech. In rejecting the petitioner's contention and ruling that the forfeiture is a permissible criminal punishment and not a prior restraint on speech, the U.S. Supreme Court said the term prior restraint is used to describe administrative and judicial orders forbidding certain communications when issued in advance of the time that such communications are to occur. Temporary restraining orders and permanent injunctions, that is, court orders that actually forbid speech activities, are classic examples of prior restraint. Now, back to Natura's book. There need not be total suppression, even restriction of circulation constitutes censorship. Grosjean versus American Press Company. In Burgess versus Chief of Staff, the search, padlocking, and sealing of the office of Metropolitan Mail, and we found formed by military authorities, resulting in the discontinuance of publication of the newspapers, was held to be prior restraint. See also Core versus Leasing. In Eastern Broadcasting versus Dans, GR 59329L, the arbitrary closure of radio station Dyer was held violative of the freedom of expression. In Mutuk versus Comelec, GR 32717, November 26, 1970, the Comelec prohibition against the use of taped jingles in the mobile units used in the campaign was held to be unconstitutional, as it was in the nature of censorship. In Sanidad versus Comelec, the court annulled the Comelec's prohibition against radio commentators or newspapers columnists from commenting on the issue involved in the scheduled plebiscite on the organic law creating the Cordillera Autonomous Region as an unconstitutional restraint on freedom of expression. In Chavez versus Secretary Gonzalez, the Supreme Court held that acts of the Secretary of Justice and the National Telecommunications Commission in warning television stations against playing the Garcia tapes under pain of revocation of their licenses were content-based restrictions and should be subjected to the clear and present danger test. They focused only on one subject, a specific content, the alleged taped conversation between the president and a Comelec official. They did not merely provide regulations as to time, place, or manner of the dissemination of speech or expression. Respondents' evidence falls short of satisfying the clear and present danger test. In Diocese of Bucolod versus Comelec, it was asserted by Comelec that the order for the removal of the tarpaulin is a content neutral regulation, while petitioners argued that it is content based because it applies only to political speech and not to other forms of speech, such as commercial speech. The Supreme Court said that the regulation may be reasonably considered as either content neutral or content based. Regardless, the disposition of the case will be the same. Content based regulation bears a heavy presumption of invalidity, and the court has used the clear and present danger rule as measure. Under this rule, the evil consequences sought to be prevented must be substantive, extremely serious, and the degree of imminence extremely high. Only when the challenged act has overcome the clear and present danger rule will it pass constitutional muster, with the government having the burden of overcoming the presumed unconstitutionality. Here, there is no compelling and substantial state interest endangered by the posting of the tarpaulin as to justify curtailment of the freedom of expression. We reiterate that the regulation involved is content based. If the test for content neutral regulation is applied, the question acts of Comelec will not pass the requirement for evaluating such restraints on freedom of speech as enumerated in Social Weather Station versus Comelec, discussed below. The restriction in the present case does not pass even the lower test of intermediate scrutiny for content neutral regulation. The message of petitioner contained in the tarpaulin, taken as a whole, is an advocacy of a social issue that is deeply believed through rhetorical devices. It communicates the desire of the diocese that the positions of those who run for political position on this social issue be determinative of how the public will vote. It primarily advocates a stand on a social issue only secondarily, even almost incidentally, will cost the election or non election of a candidate. Regulation of election paraphernalia will still be constitutionally valid if it reaches into speech of persons who are not candidates or who do not speak as members of a political party if they are not candidates. Only if what is regulated is declarative speech that, taken as a whole, has for its principal object the endorsement of a candidate only. The regulation should be provided by law, reasonable, narrowly tailored to meet the objective of enhancing the opportunity of all candidates to be heard, and considering the primacy of the guarantee of free expression, and the demonstratively the least restrictive means to achieve that object. The regulation must only be with respect to the time, place, and manner of the rendition of the message. In Jose Jesus Dicini versus Secretary of Justice, the Supreme Court invalidated Section 4 of RA 10175 or Cybercrime Law, which penalizes the transmission of unsolicited commercial electronic communications which seek to advertise, sell, or offer for sale products and services, etc., ruling that the section is unconstitutional. The court said that 1. The government has presented no basis for holding that unsolicited electronic ads reduce the efficiency of computers. Number 2, people before the arrival of computers have already been receiving unsolicited ads by mail. These have never been outlawed, and the recipient has always the option to delete or not to read them. And 3, to prohibit the transmission of unsolicited ads would deny a person the right to read his emails, even unsolicited commercial ads. And the state cannot rob him of this right without violating his constitutionally guaranteed freedom of expression. In the same case, even as the Supreme Court ruled as valid and constitutional Section 4, letter C, which penalizes online libel with respect to the original author of the post. It declared as void and unconstitutional the same provision as applied to others who simply receive the post and react to it. In the same case, the court also invalidated Section 5, which would punish the act of aiding and abetting the commission of cybercrimes in Section 4, letter C on libel. In Section 4, letter C, number 3, on unsolicited commercial communications, in Section 4, number 2, on child pornography, the court said that the provision cannot stand scrutiny. Its vagueness raises apprehensions on the part of Internet users because of its obvious chilling effect on freedom of expression, especially since the crime of aiding and abetting ensnares all the actors in the cyberspace front in a fuzzy way. What is more, formal crimes like libel are not punishable unless consummated. But the crime of aiding and abetting the commission of cyber crimes under Section 5 is not constitutionally infirm that it can be made to apply to Section 4, letter A, number 1 on illegal access, to Section 4, letter A, number 2 on illegal interference, to Section 4, letter A, number 3 on data interference, Section 4, letter A, number 5 on misuse of devices, to Section 4, number 6 on cyber squatting, Section 4 on computer-related forgery, on computer-related fraud, to Section 4, letter B, number 3 on computer-related theft, and to Section 4, letter C, number 1 on cyber sex. None of these offenses borders on the exercise of freedom of expression. Furthermore, in these cases, the actors aiding and abetting can be identified with reasonable certainty through adroit tracking of their work. In the same case, the Supreme Court said that the authority that Section 12 grants law enforcement agencies in the real-time collection of traffic data is too sweeping and lacks restraint. Nothing can prevent law enforcement agencies with these data in their hands from looking into the identity of the sender or receiver or what the data contain. the limitation associated with specified communications is no limitation at all, since it is the law enforcement agencies that would specify the target communications. The power is virtually limitless, enabling law enforcement agencies to engage in fishing expeditions, threatening the right of individuals to privacy. But in Gonzalez versus Comelec, the court upheld the validity of the law, which prohibited, except during the prescribed election period, the, mar- the making of speeches, announcements, or commentaries for or against the election of any party or candidate for public office. When the prohibition on prior restraint does not apply, WOS, when the nation is at war, the government can prevent publication about the number or location of its troops. Number two, obscene publications. Number three, security of community life may be protected against incitements to acts of violence or overthrow by force of orderly government. Near versus Minnesota. Subsequent punishment. The concept is the aspect of freedom from liability subsequent to publication precludes liability for completed publications of views traditionally held innocent. Otherwise, the prohibition on prior restraint would be meaningless, as the unrestrained threat of subsequent punishment by itself would be an effective prior restraint. Thus, opinions on public issues cannot be punished when published merely because the opinions are novel or controversial, or because they clash with current doctrines. This fact does not imply that publishers and editors are never liable for what they print. Such freedom gives no immunity from laws punishing scandalous or obscene matter, seditious or disloyal writings, and libellous or insulting words. As classically expressed, the freedom of the press embraces, at the very least, the freedom to discuss truthfully and publicly matters of public concern without previous restraint or fear of subsequent punishment. For discussion to be innocent, it must be truthful, must overcome something in which people in general take a healthy interest, and must not engender some important social end that the government by law protects. Lifted from the Book of Bernas, content based and content neutral. It is not enough to determine whether a challenged governmental act constitutes some form of restraint on freedom of speech. A distinction has to be made whether the restraint is one, a content neutral regulation, or two, a content based restraint or censorship. Content based regulation, restraint, or censorship is where the restriction is based on the subject matter of the utterance or speech. Chavez versus Gonzalez. A governmental action that restricts freedom of speech or of the press based on content is given the strictest scrutiny in light of its inherent and invasive impact. Only when the challenged act has overcome the clear and present danger rule will it pass constitutional muster, with the government having the burden of overcoming the presumed unconstitutionality. Unless the government can overthrow this presumption, the content based restraint will be struck down. Clear and present danger test whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. It is a question of proximity and degree. Requisites of a valid content based regulation. We can use HIR, which is the government must show the type of harm the speech sought to be restrained would bring about, especially the gravity and the imminence of the threatened harm. Otherwise, the prior restraint will be invalid. The regulation which restricts the speech content must serve an important or substantial government interest, which is unrelated to the suppression of free expression, and the incidental restriction on speech must be no greater than what is essential to the furtherance of that interest. Same case, Chavez. Content neutral regulation. A content neutral regulation is merely concerned with the incidence of the speech, or one that merely controls the time, place, or manner and under well defined standards. Subject to intermediate approach, when the speech restraints take the form of a content neutral regulation, only a substantial governmental interest is required for its validity. Because regulation of this type are not designed to suppress any particular message, they are not subject to the strictest form of judicial scrutiny, but an intermediate approach, somewhere between the mere rationality that is required of any other law, and the compelling interest standard applied to content based restrictions. The test is called intermediate because the court will not merely rubber stamp the validity of law, but also require that the restrictions be narrowly tailored to promote an important or significant governmental interest that is unrelated to the suppression of expression. O'Brien test for a valid content neutral regulation. Sinunog, we can use that. It is within the constitutional power of the government. It furthers an important or substantial government interest. The governmental interest is unrelated to the suppression of free expression, and the incidental restriction on alleged freedom of speech and expression is no greater than is essential to the furtherance of that interest. In Gonzalez versus Kamalik, juror number L27833, the court said that the term clear seems to point to a causal connection with the danger of the substantive evil arising from the utterance questioned, while present refers to the time element identified with imminent and immediate danger. The danger must not only be probable, but very likely inevitable. In Saldivar versus Sandigan Bayan, on the argument of Tanod Bayan Raul Gonzalez that it was error for the court to apply the visible tendency rule rather than the clear and present danger rule in disciplinary and contempt charges, the Supreme Court said that it did not purport to announce a new doctrine of visible tendency. It was merely paraphrasing Section 3, letter D, Rule 71 of Rules of Court. Under either the clear and present danger rule or the balancing of interest test, the statements of Gonzalez transcended the limits of free speech. The substantive evil consists not only of the obstruction of a free and fair hearing of a particular case, but also the broader evil of the degradation of the judicial system of a country and the destruction of the standards of professional conduct required from members of the bar and officers of the court. In Iglesia ni Cristo versus Court of Appeals, the court held that the X rating would have been justified only if there was a clear and present danger of an evil which the state has the right to prevent. In Biva Productions versus Court of Appeals and Hubert Webb, the Supreme Court held that actions of RTC Paranaki and RTC Makati in restraining the exhibition of the movie, The Jessica Alfaro Story, violated the petitioner's right to free expression. The court noted that the lower court specifically failed to lay down any factual basis constituting a clear and present danger that would justify prior restraint. As applied to assembly and petition, the Supreme Court declared in JBL Reyes versus Bhagat Singh that the denial of a permit to hold a public rally was invalid as there was no showing of the probability of a clear and present danger of an evil that might arise as a result of the meeting. The burden of proving such eventuality rests on the mayor. Dangerous tendency rule, as explained in Cabansag versus Fernandez, if the words uttered create a dangerous tendency of an evil which the state has the right to prevent, then such words are punishable. It is sufficient if the neutral tendency and the probable effect of the utterance were to bring about the substantive evil that the legislative body seeks to prevent. Balancing of interest test when particular conduct is regulated in the interest of public order and the regulation results in an indirect conditional or partial abridgment of speech. The duty of the court is to determine which of the two conflicting interests demands the greater protection under the particular circumstances presented. American Communications Association versus Dodds. In Saldivar versus Sandigambayan, the Supreme Court said that the clear and present danger rule is not the only test which has been recognized and applied by the courts. Another criterion for permissible limitation on freedom of speech and of the press is the balancing of interest test, which requires a court to take conscious and detailed consideration of the interplay of interests observable in a given situation. Ayer Productions versus Capulong. Assembly and petition. The right to assemble is not subject to prior restraint. It may not be conditioned upon the prior assurance of a permit or authorization from government authorities. However, the right must be exercised in such a way as will not prejudice the public welfare, as held in De La Cruz or De La Cruz versus Court of Appeals, GR 126183. This case, the Supreme Court said that by staging their mass protests on regular school days, abandoning their classes and refusing to go back even after they were ordered to do so, the teachers committed acts prejudicial to the best interests of the service. If the assembly is to be held in a public place, a permit for the use of such place and not for the assembly itself may be validly required. But the power of local officials in this regard is merely one of regulation, not prohibition. Primicias versus Faguzo. Thus, in BP 880, Public Assembly, let's do that on the next upload.